and the Legal 500. We thank the Legal 500 team, and special thanks to the Legal 500 team who is with us today, the Managing Director, Mr. Gothrop, and the Head of GC Powerlist, Mr. Basra, for their cooperation and effort in organizing today's webinar. We are happy to receive all your questions on the Q&A box, which will be answered and discussed at the end of this session. It's our pleasure to start this webinar with an opening remarks from Mr. David Gothrop. Mr. David, please.
Well, good afternoon, everybody, and I'm delighted to be here on this webinar and to be working with our excellent partners, the Saudi Centre for Commercial Arbitration. Thank you for everybody who's attending this session. I know that you're all very busy and time is precious, so we very much appreciate you spending time with us this afternoon. I think we've got a really interesting session lined up for you. And we at the Legal 500 are honoured to be working with two excellent speakers, Dr. Hamid Murray and Mr. Christian Alberti. I know they're going to be fantastic and will provide us all with some interesting insights. So I hope you're all familiar with the Legal 500. We highlight excellence in the legal industry by ranking and recognising the very best lawyers, law firms, general counsel, and in-house counsel in the Middle East and across the globe. We see the Middle East as a real centre of legal excellence, and as such, we've increased our footprint in the region in recent years. Not only do we rank law firms in Saudi Arabia and across the Middle East, but we also have a range of activities which engage with firms and in-house counsel, ranging from specialised research, data products, publications, and events. The GC Powerlist Middle East was launched in 2015, and but for the pandemic, it would have been celebrating its 6th edition in 2020. And we're very much hoping that the GC Powerlist Middle East will be back up and running and will be over in 2021. But the Powerlist Middle East forms part of a global series which recognizes the leading and most influential in-house lawyers operating in over 80 countries across the world. In 2019, we also launched our first Middle East Regional Dispute Summit, which was attended by over 230 general counsel and senior in-house lawyers across the Middle East. And we're very much hoping that the next summit will be able to take place in June of 2021. So we hope to see many of you in person at that particular event. And the Middle East Dispute Summit is again very much part of a global series of events dedicated to dispute resolution. We've held similar events in the UK, in Singapore, Germany, Sweden, Turkey, India. And in 2021, we will extend the series into Australia, Hong Kong, and across 5 cities in the US. But with the growing trend for arbitration to be the preferred method of dispute resolution, we've recently launched our new series of arbitration powerlists. And these are recognizing the very best arbitrators in the world. The series started in the UK in 2019, and this year we're producing editions in the CIS, Africa, and Central Eastern Europe. In 2021, the series will be further extended into Latin America, the Nordics, Southeast Asia, and you'll be glad to hear, yes, the Middle East. So earlier this year, we also launched our first Middle East M&A Summit, which was in Dubai, and that will take place again in 2021. We've also held events in Kuwait, Bahrain, Lebanon, Qatar, and Egypt. And we really were looking forward to an event in Saudi Arabia in this year, but unfortunately, obviously, because of the pandemic, that's had to be put on hold. We're very much hoping that we will be able to run that event in the next year. And our plans for Saudi Arabia also include a one-day summit, which we hope will provide a really great platform for lawyers within the region to discuss and debate amongst their peers kind of key legal and business challenges that are facing them. So it's a busy time for us. Yes, we've had the pandemic to deal with, but it's been a busy time both in the Middle East and across the globe. We want to do a lot more, We want to do more within the arbitration and disputes field. We want to do a lot more things across the Middle East. And I'm hoping that in the due course of time, I'll get to meet in person many of you at some of these events. But if you would like to know more about any of the things I've just spoken about, or more about Legal 500 in general, please don't hesitate to give me a call or email after this event. But it's very much an honor. All I'd like to say really is an honor to be here today. And I would like to thank the Saudi Center for Commercial Arbitration for this opportunity. We are honored to be part of this event, and I hope everybody has an amazing afternoon. So thank you very much.
Thank you, Mr. Goltrib. Of course, we wish to have the honor of meeting you in the nearest future, hopefully. And before we move forward to the next speaker, I would like to invite you, I would like to invite all participants actually to participate in the survey questions, which should be appearing on your screens now. And now, SCCA CEO Dr. Hamid Mira will shed light on the most recent updates on the ADR landscape in Saudi Arabia. Please, Dr. Hamid.
Good morning, good afternoon, good evening, all around the world, ladies and gentlemen, distinguished guests. It's a great pleasure for me personally and for SCCA to co-host this really important webinar with our colleagues in Legal 500. And also I would like to thank David, Legal 500 for their partnership in conducting this webinar. And also I would like to thank all of you for giving us part of your time to shed light about some updates in Saudi Arabia in particular. Before I go to my presentation, I think it's very obvious for any country, if it wants to be ADR friendly jurisdiction, there is a need for different kind of support. And I can say the three most important kind of supports could be illustrated in legislative support, governmental support, and also judicial support. And these three pillars will be the first topic that I'm gonna cover very quickly about Saudi Arabia. And finally, I will shed light about SCCA as international center in Saudi. I think maybe part of you don't know that the first law enacted in Saudi related to ADR was 90 years ago, by His Majesty King Abdul Aziz, which is the first commercial court law. Some articles in that law was about arbitration. And after that, different laws and regulations issued in Saudi related to ADR. For example, in 1983, Saudi Arabia was the first Arab country to enact a dedicated comprehensive law related to arbitration. And 70 years ago, the practice of arbitration started in Saudi in different chambers in Saudi. But I can't say the golden year for ADR in Saudi was 2012. In that year, two important laws enacted. The first law is the new arbitration law and also the enforcement law. And I will shed light about these two important laws in the coming slide. As I said, the ad hoc arbitration practiced in Saudi for the last 7 decades, 6 to 7 decades, but the institutional arbitration started in 2014 by the establishment of the SCCA by a cabinet decree. Going back to the new arbitration law in Saudi, I think it's really important to mention this new arbitration law is based on unicitral model law. And as any law based on unicitral, there is common, you can say, aspect related to that, such as giving more parties autonomy in terms of selecting any applicable law, any institutional rules, any language, any venue, any arbitrator, without any restriction related to, for example, religion, gender, nationality, and this also in SCCA. Also, this law gives more court support in terms of appointing arbitrator, interim measure, say it. Also, I think one of the game changers, one of the most important thing in the new arbitration law in Saudi, the arbitral award is final, is not appealable. There is only a challenge within 60 days. So this is really important elements in the new arbitration law. And also the issuance of the enforcement law, I can classify it as a quantum leap for arbitration in Saudi Arabia. Some of the aspects related to that, moving the enforcement of the arbitral award from the administrative or the board of grievance to specialized enforcement court, and also within that courts there is specialized judges with special education and training, so to help in that. And you will see the result of that in numbers in some slides will come. The second example, just I would like to mention, in only in 2019, more than 6 royal decrees, laws, and regulations has been issued to support arbitration and ADR in general. One of the most important royal decrees in January 2019, maybe some of you knows that the governmental entities were restricted from using arbitration in settling their dispute, even with the foreign investor or with local companies. But the first change started with the royal decree in 2019 by encouraging governmental agencies, state-owned companies to settle their dispute, especially with foreign investor, through arbitration and with SCCA or under SCCA umbrella and SCCA rules in particular. Another big milestone, in July 2019, the new Saudi government tenders and recruitment law has been issued. And one of the most important things to highlight here, also it makes it much easier in practice for the governmental entities to use arbitration, moving the approval from the Prime Minister to the Ministry of Finance. So now any governmental entities, if they would like to include an arbitration in their contract, they have to coordinate with the Ministry of Finance. Another examples, the new franchise law mentioned clearly, such as you can see here in the article number 25, it gives the authority to settle the dispute in franchise agreement or any application of the law by alternatives, by ADR, such as arbitration, mediation, conciliation. Also different laws and regulations, but these just an example in only 1 year to show to let you see, the rhythm that we have in Saudi. The second aspect that I would like to mention is the governmental support. And let me give you just very quick examples. The first example, after the issuance or after the new recruitment law has been enacted, the Minister of Finance in December 2019, he issued a resolution to approve 14 laws related to that, government recruitment contracts. In all of these contracts, in all the 14 contracts, the model clause in dispute resolution is institutional arbitration under SCCA rules and under SCCA management. Another example, we are proud to say that Saudi Arabia is the 4th country globally to ratify the Singapore Mediation Convention, the convention related to international settlement agreements resulting from mediation. And also Saudi Arabia was one of the founding signatories for that convention in August 2019. And here also you can see some other examples. For example, the Ministry of Commerce, they included SCCA model clause in some of their guiding contracts, as you can find that in their website. There is a lot of initiatives with the Ministry of Investment, with some other like CITC, some other governmental entities. Let me move very quickly to the third pillar or the third kind of support, which is the judicial support, which is really, really important and crucial for any country to have a judicial support. Here is also some examples. First of all, we signed as SCCA with the Minister of Justice to refer cases from the commercial court to SCCA to be settled through mediation. And also we are proud to say we reach very high percentage of settlement from that cases referred from the commercial court to SCCA. Also, now the commercial court in Riyadh, they started to request SCCA to nominate and to nominate arbitrators for the ad hoc cases. Some other example also, now there is different, workshop has been conducted with SCCA, with the related judges, and also now we are going to conduct a specialized training for the related judges. These only some examples of the initiatives has been started and conducted with the Ministry of Justice. In terms of enforcement, we saw all of these efforts resulted in numbers. So the enforcement of foreign and local arbitral awards is getting higher and higher. And here you can see some example has been announced by the Minister of Justice. To give example for some cases from different parts of the world, they has been enforced in Saudi, and which is giving the new norm in Saudi Arabia. Going very quickly to SCCA, as I mentioned, SCCA is the first institutional arbitration center started in Saudi. SCCA has been established by a cabinet decree in 2014. We launched officially in October 2016, so we are now 4 years old. In July 2019, the SCCA statute has been also approved by a cabinet decree, which is give SCCA more independent, more impartiality, more professionalism, and also it enhances SCCA governance. So we are independent, we are not for-profit organization, independent from the government, and at the same time independent from the private sector. One of the first decision has been taken by SCCA board to go for a partnership, strategic partnership with the one of the most respectable arbitration center globally, which is the AAA and their international arm, the ICDR. So that partnership resulted in drafting SCCA arbitration mediation rules, also getting our case counsels trained in New York, and also conducting a specialized program here in Riyadh, Jeddah, and Dammam with our partner AAA ICDR. Another examples, but these some of the examples to show SCCA from day one committed to be within the international best practices. So because of that, we aligned with one of the most known and respectable center. Since that time, as I mentioned, our rules, especially the arbitration mediation rules, our code of conduct, our different laws has been issued after that. And also our case counsels, our team, we are trained to these rules. Now we have 4 offices in Riyadh, Jeddah, and Eastern Province, and also in King Abdullah Economical City. After the issuance of our rules, different well-known law firms, they wrote about the development in Saudi Arabia and ADR in general, and also in SCCA in particular. And also they mentioned our rules. We are proud of that, such as the brands that all of you knows about it. Another aspect of the readiness of SCCA, our roster. Yes, also we have as administrative team, we have that well-diversified team in terms of gender, nationalities. Yes, we have a small team, but also they are from 11 nationalities. They are speaking more than 6 languages. And at the same time, our roster, we are proud to have more than 300 arbitrators and mediators. They are from 25 countries all around the world. They are speaking to 12 languages. And also they are specialized in more than 20 specialized fields, such as oil and gas, energy, banking, Islamic finance, construction, etc., etc. Yes, again, we are only 4 years old center. And as you know, sometimes center takes to 5 years to 8 years to register the first case. We are proud and happy just within 4 years. we could register all of these cases in all of these industries. As you can see from the chart, the biggest part of our cases was in construction. More than 55% of our cases is in construction. But as you can see, capital market, banking and finance, aviation, entertainment, engineering, medical, etc. Another part of the trust that we are proud of, our parties, the parties of the cases, not only from Saudi Arabia, all the flags that you can see now in the slide in front of you, the parties in our cases, they are from all of these countries, as you can see, from North America, Europe, and also Asia, and in addition to the region. As I mentioned, from day one, we are committed to be international. We are committed to be independent. We are committed to be within the best practices, and to institutionalize that. In last October 2019, SCCA established an advisory committee, and as you can see here, 14 well-known rock stars, experts from all around the world, from 11 countries all around the world. Now they are sitting in SCCA advisory committee to help us in developing our rules, updating our services to be aligned with the best international practices. All that efforts resulted in big, you can say, a suite of services, starting from arbitration to mediation, emergency arbitration, ODR, all of these products and services. My colleague Christine Alberti, the Chief of ADR General Counsel of SCCA, will take you through it very quickly to see that we prepared ourselves to serve in different industries, different kind of businesses, starting from giant companies, blue chips, to SMEs, to entrepreneurs, local and international, which you can see the details in few seconds with Christine Alberti. Thank you again. I will be more than happy to answer your questions in the Q&A part of this webinar, and at any time you can send me emails, and also you can reach us through my contact details. Thank you again, and I'll see you by the end of this webinar.
Thank you, Dr. Hamid. Ladies and gentlemen, we will be sharing now the second set of questions, and kindly, can you please share your questions in the Q&A box so we can answer as many as possible at the end of this session. So, and now moving to the next speaker, kindly allow me to introduce Mr. Christian Alberti, SCCA Chief of ADR and General Counsel. Mr. Chris, please.
Thank you very much, Noof, and it's also a pleasure for me to be with you today on this afternoon or morning, wherever you're sitting right now. Allow me quickly to click on the answers to this poll question right now, so I see actually the full screen before I share. Again, a pleasure for me to be with you today, and I echo Dr. Hamid's words. It has been quite a fascinating year that we have been going through, and we have made great strides to further enhance the products of the SCCA, but also to help the kingdom to get to new heights. A lot of success, a lot of change has occurred in the last month alone, and the last 2 years are just fascinating to follow. My daunting exercise today is to get you through in 20 minutes through 2 distinct topics. The first one will be recent SCCA services that have been introduced in our repertoire to make sure that there's something for everyone. And the second topic will be recent trends in Saudi case law. We'll take these in turn. Now, in terms of recent services to the SCCA portfolio, we have, of course, arbitration. Of course, we have mediation. And in both of those sections, we have added new services. But perhaps where we have seen the best increase, or the largest increase in new services, is in the limited service suite. And then finally, we also have been more engaged with the court system to ensure that we have also access to them. Now, arbitration. We have, of course, SCCA arbitration rules. That's the backbone of it all. I will very briefly try to go through this with you to give you some highlights as to what the SCCA arbitration rules do have, let alone to say, or suffice it to say, that international best practices have been preserved here. We have all the usual maxims, doctrines, think of competence, the arbitrator can judge in his own jurisdiction, or separability doctrine, the arbitration clause can be separated from the main contract. But those are a couple more points here that are listed for you to show you that the arbitration rules are quite comprehensive. And you see here that we have also embedded in our rules that the parties can choose their own representative, which is a very important fundamental right for every party. Parties are inclined or should usually try to agree to an arbitrator. If they fail to do so, then of course we can help. Our default is one arbitrator unless there's disagreement and we find 3 arbitrators might be more appropriate. Otherwise, we use what we call the strike and rank list method. Lists will be sent to both sides depending on expertise qualifications requested. The parties strike the list, the parties rank the list, the highest ranked arbitrator will be appointed. And all that comes from our so-called SCCA arbitrator roster, a roster that Dr. Hamid mentioned earlier with lots of hand-selected expert arbitrators for every industry that we see in our caseload. Now, arbitrators, of course, have to be independent, impartial, and yes, they do have a duty to disclose. And if we have such a disclosure, we have now in place also something we'll address in more detail in a moment, a so-called Committee for Administrative Decisions. What they do is they determine challenges as arbitrators, but also number of arbitrator disputes as well as place of arbitration disputes. Our rules to allow for joinder. And the next 3 bullet points I will stress a little bit further because it's very important to understand that a lot of people talk about making the arbitration process efficient and cost effective. We try really to force this upon everyone in the best possible way. In fact, our rules do show that we wish the arbitrators to conduct the proceedings in the most expeditious way by use of technology. Emails are being used everywhere now these days, but more often than not, you also see now links being shared to documents. Think of the pandemic, remote hearings. So we have seen this becoming the new norm. Who would have thought about this 10 months ago only? But also parties are required to avoid any unnecessary delay and expense. This particularly is important when it comes to the exchange of information, where most time is spent for one way or another, for one reason or another. And parties are here again requested to make this as efficient, as economic as possible. It's not always easy, but it's a very important point to ensure that we don't waste time in arbitration. All that against the backdrop of equality of treatment, that is, parties have the right to present their claims, their defenses, your right to present your case. So due process considerations are always at the forefront. We have emergency relief. I will address that in more detail later. Interim measures, of course, if something needs to be done very quickly. Expedited procedures for cases that are not in the larger scales. I will address that in turn as well. Perhaps also worth mentioning, awards have to be rendered within 60 days of the date that we close the hearing. And of course, our SCCA arbitrations are confidential, one of the keystones as well here. And we have transparency when it comes to fees. We use a so-called ad valorem fee schedule that looks at the claim amount in order to calculate what the fees are for the process. So just a quick overview of the SCCA arbitration rules, which is the bedrock of it all. I mentioned the expedited procedures. The expedited arbitration process is quite straightforward and addresses smaller claims. In fact, your claim has to be 4 million or less, and the agreement has to be signed on October 15 of 2018 or later for the expedited procedure rules to apply. They do apply in tandem or on top of the SCCA arbitration rules and replace or modify them where in conflict. Now you can opt in, you can opt out, irrespective of the claim amount or date of the agreement. We, of course, will appoint only one arbitrator. Again, it's supposed to be an expedited process. 1 hearing day is envisioned. You can even have the decision based on documents only. Again, another way to expedite things and keep things simple. Absent any agreement by the parties on the sole arbitrator, we help with a strike and rank list method again, but this time it's 5 names. You can only strike 2 names. And the list has to be returned in 10 days from the date of receipt. Again, to show that this is a process that moves on very, very quickly. As for the award, of course, it's binding. We know that. You have to, the arbitrator has to render the award within 30 days of the date of closing of the hearings instead of 60 days under the SCCA arbitration rules. So again, half the time. And in any event, the award has to be rendered within 180 days from the day of the arbitrator being appointed. So again, a very quick, fair process. Now, claims can be even smaller than what would justify a full-blown arbitration. So we have now in place an online dispute resolution mechanism. with platform behind it. So technology is involved here as well, as you can see from the slide. This is ideal for claims that are not exceeding 200,000 riyal. Of course, you can file around the clock. Online exchange is being done via the platform. That even includes communications, so even emails are not necessarily envisioned. Responses to claim or counterclaims have to be sent or circulated within 10 days of the receipt. Person hearings are not envisioned unless required, and for that we have a dedicated platform. And importantly here, the final award has to be rendered within 30 days of the arbitrator appointment, which means in theory, in practice, you can have a solution within 50 days of the date of filing. And that depends on party cooperation and also what the circumstances might be the case. But 50 days, I suggest, is quite quick when it comes to claims in that range. So that translates into time and cost savings, of course, and needless to say, the platform is secure. Now, just to summarize this all into one line, when does what apply here? So the SCCA arbitration rules do apply throughout the entire board, but when the claim amount is 4 million or less, automatically the expedited procedures will apply on top. When you have claims below 200,000 or 200,000 exactly, you can opt in by agreement, explicit agreement, into the ODR protocol. One last point on arbitration, that's emergency arbitration. We have started that in 2018. If the contract is signed on or after October 15, it applies automatically. What we do, we appoint an emergency arbitrator within 1 business day. Emergency arbitration, for those who do not know that, that's very important when you have a situation where a claimant cannot wait until the main tribunal is appointed. Think of situations where, for example, the respondent will disappear with the assets, or you need to preserve some of the status quo. Think of evidence. Those points can be addressed by emergency arbitration to have an interim solution until the main tribunal is appointed and can take over. It's a very quick, efficient way to help claimants when there is need. Challenges are allowed within 1 business day. They will be addressed within 3 business days after the challenge has been fully briefed. Replacements to occur within 1 day. And once the emergency arbitrator is appointed, he or she has 2 business days to provide a procedural timetable to allow the opposing side to basically explain its side of the case. So it's not an expedited process. The outcome is an order or interim award. Most importantly, perhaps for users, it has to be rendered within 14 days, 14 days from the file handover to the emergency arbitrators. It's a very quick process. In terms of standards, perhaps interesting to see that this mimics what you may know as Article 17A of the UNCITRAL model law. As an applicant, you have to show that the harm is not adequately repairable by an award of damages. And in addition to that, you also have to show that the harm substantially outweighs the harm that is likely to result to the other side if you win. And then finally, you also have to show that there's a reasonable possibility that you may win or succeed on the merits. Again, emergency arbitration, very successful process. Mediation briefly. Here again, to no surprise, party choice to be represented, though I always remind parties that it is good to have the decision maker in the room. So represent is a good thing, no doubt, but it's also good to have that decision maker in the room when it comes to making the deal. The mediator will be appointed if the parties cannot agree. We again have a mediator roster that helps parties to do that with the list method. The mediator, of course, has to be impartial and independent. That is also a duty to disclose. But perhaps in contrast to arbitration, if there's a challenge or an objection to the mediator, there will be an immediate replacement. So there's no decision on the challenge. Mediators they are there to help parties to facilitate the process, the negotiation that is. So there's a principle of party self-determination. That is, the mediator is there to help, not to drive, not to impose a settlement, if you will. So again, just there to attempt to help them reach an agreement. The mediator may create or allow for so-called caucuses or separate meetings, and even allow for separate communications, whatever helps the mediator to better understand the case and help the parties to agree. Privacy confidentiality is preserved even after any other processes that may follow in case of failure. And as with arbitration, there's transparency when it comes to the fees. Even here, we have an ad valorem fee schedule. Another object that we have done, a product that we have rolled out in light of the pandemic in 2020, earlier this year, is the so-called COVID-19 Emergency Mediation Program, or in short, EMP. It distinguishes itself from the classical mediation by being fully remote, thanks to a video conferencing platform. Perhaps most importantly, you can now convert, if successful, your settlement agreement into a final and enforceable bond, and that without court intervention. So no homologation process as you may from other jurisdictions. It is truly a process where you can go start to finish from the settlement into the enforceable bond, and direct enforcement is possible and only subject to very limited grounds. Another point here perhaps to mention is that the fee schedule has been reduced in light of the pandemic. And we're also rolling out a service now for parties that are a little bit scared of contacting each other. And we try with our mediation facilitation service now to help parties to find agreement to mediate. EMP, one of our latest products. Now quickly, limited services. We have two lines of services. The first one is selection and appointment. Three sub-services are here: list only service, list and appointment, and administrative appointments. The first one is essentially a product where parties can come to the SCCA and simply ask for a list, a simple list, 5, 10, 50 names based on qualifications and expertise. And we'll look at our roster and then provide that list. That's it. It's for one party or both parties. Very quick access to a qualified roster list in order to move forward with your matter in an ad hoc setting. The listed appointment service builds on the list only service by also now having the second party on board. That is, the parties will strike and rank the list. We appoint the arbitrator, we check for conflicts, we determine the challenges, and if necessary, we substitute. As you may know, appointing arbitrators in ad hoc cases is a very complicated thing at times, because that is where a significant delay usually occurs, and sometimes even a complete standstill. So this is a service where parties can really rely on a third neutral party, the SCCA, as a neutral authority to make swift and efficient decisions in that regard, so that parties can move on with the process. And then finally, when parties cannot agree on the time of the day, we make administrative appointments as well. That is, the parties come to the SCCA and can agree to have us simply appoint the arbitrator, determine the challenges if there is anything. That happens without any further intermediary steps. So a very quick process, in and out, here's your arbitrator, and you can move on with this process. The second line of service has to do with, or is delivered by, the so-called Committee on Administrative Decisions. In all brevity, this is a decision-making authority that helps in SCCA administered, but also ad hoc cases, that is non-administered cases by the SCCA. So parties can take advantage of that against a fee as well. The scope is limited, as I mentioned earlier, to challenges, number of arbitrator disputes, and also place of arbitration disputes. The structure is very straightforward: 5 members, quorum are 3 members, that is 3 members have to decide every dispute. And in case of an emergency, they will meet more frequently than just once a week. You see 3 persons here that bring a lot of institutional knowledge to the table. We have here the former director of the Cairo Center. We have the former Deputy Secretary General of the ICC. And I have worked my past life, so to say, as the Assistant Vice President for the AAA ICDR in New York. So institutional knowledge is always important to build trust in the decision. And we hope that we have accomplished that with this very distinguished committee. Now, briefly, Appeals Court Nomination Project. What is that? We have talked to the Appeals Court in the past. We understand that, of course, in ad hoc cases, when there is an impasse to appoint an arbitrator, parties have to go to the court, to the Appeals Court, and according to the law. And we found a way to assist the court to expedite things, in a sense, to help the market in a way to move forward more quickly. As we have heard, this may take weeks, if not months, to get an arbitrator appointed by the court. We launched it last year, end of last year. We're happy to say we're at 55 nominations where we nominate an arbitrator for the court, and the court then subsequently appoints that arbitrator. Perhaps worth mentioning here, we had the first female arbitrator nominated by us on August 20th, and the court has appointed that female arbitrator without any further feedback, meaning everything went smooth through. So as far as we know, this is the first of its kind. Yes, we have seen female mediators before. We have appointed female mediators before, but this done by a court, that's a first. Now let me move on to the second topic in all brevity, recent trends in Saudi case law. I try to put together for you a selection of cases that establish known principles, you may say, but it's important to see them also in case law, to have confidence in what Dr. Hamid has said, that Saudi Arabia has indeed an arbitration-friendly jurisdiction, which is the backbone of it all, as we know. Now, the first case really is important to establish an old principle. I mentioned the doctrine of severability earlier. This is about the independence of the arbitration clause. Here in 2012, that's the year where the Saudi arbitration law went live, the Riyadh General Court had a case where the parties' contract contained a general reference to Saudi legislation, not Saudi law. It also specified that all terms of the contract would be interpreted according to this law. The contract also had an arbitration clause under the ICC rules, and the claimant later on tried to avoid arbitration and made reference to the general provisions in that contract, and that these should prevail over the case in conflict with an arbitration agreement. And if in conflict, would exclude any norms such as the ICC arbitration clause, so that only the Saudi arbitration law would remain. The respondent, of course, submitted a motion to dismiss, and the court eventually sided with the respondent and concluded what we know as the doctrine of severability, is that the arbitration clause is indeed independent from the main contract. Perhaps more importantly, it is not supposed to be interpreted or limited in light of other substantive terms of the contract. You should read it on its own. Another decision that may seem on, when looked at first time, very obvious, but it, again, this had there was a devil in the detail here as well. This was about the scope of judicial review of arbitration awards. Now you may say, of course, the substance should not be reviewed by the court. And in fact, here the court has decided it has no jurisdiction to examine the substance of the decision made by the tribunal. What we had here was the claimants that were challenging awards, so not more than one, on the ground that were manifestly ill-founded. And in addition to that, they also argued that evidence submitted was insufficient to establish the case. Now, aside from the court saying it has no jurisdiction to revisit the merits, the court also clarified, which I found very important, what Article 50 of the Saudi arbitration law actually says. And that is, it gives you the reasons when you can set aside an award. And among other things, it says that is the case if the arbitration agreement is null and void, when there are any due process issues or procedural requirements have not been met. Maybe the findings of the tribunal are beyond the scope of the arbitration agreement, or there's any issue with public policy or Sharia concepts. So again, the court has said these are the reasons. That was not one of them. You cannot say it's manifestly ill-founded or the evidence, I don't like it, hence please set aside the award. That did not work in 2014. It does not work today. Talking of Sharia compliance, two cases that are of interest here. That we're also being asked always by foreign clients in particular, what is it with the Sharia compliance? How do we even know how that works? So at least two decisions I found very suitable to present to you today. The first one is from 2011 from the Board of Grievance. And here the Board of Grievance basically said, you cannot just simply say it's not Sharia compliant. You got to give a little bit more than that. In fact, the court said that it would only be considered as a set-aside reason under Sharia if it violates a well-established or authoritative and an unambiguous provision of the Quran or Sunnah. Similarly, a year earlier, the Board of Grievance in 2010 also found that an award would only be considered inconsistent with the Sharia if it violates an authoritative and unambiguous text. So again, not any reason will do it. You have to argue a reason that is known under authoritative texts. The next decision is about the discretion of conducting a proceeding and establishing facts as the tribunal deems appropriate, a concept that's embedded in the SCCA rules as well. Here at the outset, perhaps worth mentioning again, Article 50 sets out when you can set something aside. And among other things, it also said that the tribunal must take into consideration that it should meet certain conditions if the award by violating this would actually affect its content. Another reason is if the award is based on false arbitration proceedings that have affected it. What happened here is that the court had to grapple with a situation where the tribunal had appointed a technical expert and later on decided, well, we don't need that expert anymore. So that on its own does not constitute a ground to set aside the award. So it was argued by the plaintiff in that case that the arbitrators were going beyond of what they should have been doing. And the court made very clear in 2015, the Riyadh Appeals Court decision, that the tribunal has the discretion to decide how to conduct the proceedings. Very important. Another thing that it also found that deciding a case based on submissions only is not a violation of due process. Very important here as well. Perhaps most importantly on point, what happened here, the court stated that the scope in terms of the mission of the expert, falls within the discretion, sole discretion of the tribunal, and if they don't follow through with that, that does not violate the party's right to due process. Very interesting case occurred in 2018 by the Dammam Court of Appeal. Here, perhaps at the outset, brief introduction to Article 40 of the Saudi arbitration law. It says that unless the parties agree to a time frame, then the award shall be issued within 12 months from the date of commencement. If it does not happen, then either side can ask the court to terminate the arbitration process. And that was exactly what happened in 2018 in this proceeding. The plaintiff tried to have the court terminate the ad hoc arbitration, which exceeded the 12 months without an award having been rendered yet. The court went back to the tribunal and asked for more explanation, and the tribunal explained we needed a technical expert. And in fact, we asked the parties to advance the cost of that expert, and it was the very claimant, or the plaintiff in that case, that had not advanced its own share. So eventually the court denied the motion to terminate the arbitration process because it exceeded 12 months, because it found that the tribunal needed to appoint that expert. It further found that the tribunal was not at fault to delay the process. And in fact, what was most striking here, I found, is that it found that the provisions relating to the period of arbitration are just there to expedite the resolution of the dispute. So it's not absolute in nature that you have to do this in 12 months. In fact, under the SCCA rules, we have a different time limit. And in fact, here it does not apply. This case would not have been before the court because parties agreed to the SCCA rules. Had they agreed to the SCCA rules, the time frame of 12 months would have been changed anyway. Three more quick awards that caught my attention. Correction of award. In 2010, the grievance board made very clear that the correction of an award is for the arbitrators, not the court. Corrections could be, as you may know, a correction of clerical mistakes, typographical mistakes, or computational mistakes, not the merits, of course. But again, the court made very clear that the request to correct an award for those three reasons I just mentioned falls beyond the scope of the court's mandate. It is indeed for the arbitrators. Another decision that is interesting and shows how courts in KSA have been very efficient with running arbitration, court proceedings that deal with arbitrations, and that has to do with the enforcement order as part of the challenge procedure. What happened here in 2014 with the Riyadh Appeals Court, a party tried to set aside an award, and the court has denied that motion. Not only that, it has actually then enforced the award because it allowed for the other side to basically submit the enforcement request in the same proceeding. That is to say, you don't need to start a new process. You can actually submit the same request in the same proceeding. Finally, one question that we get frequently from international parties is, so what is it? I have a foreign award. Can you enforce it in Saudi Arabia? Here in 2016, in June 2016, this fear has been put to rest. We have learned of one case at least that was handled by DLA Piper. They announced that the enforcement court in Riyadh decided and enforced 18.5 million USD award, ICC award that was rendered in London for its clients and against the Saudi party here. What I think was most striking here is that the enforcement court did that in 3 months. Yes, granted, those of you who know the case, perhaps there was some history to this, but once it was moved over to the enforcement court, it took 3 months to issue the enforcement order. In closing, perhaps allow me to say that finding these judgments is not an easy task. I am very happy to say that the SCCA is actively looking into judgments. We're actively collecting those. We're actively working on trying to register these cases by topic of interest. And in the near future, we hope to have some more information on this by form of articles or other means to share this news. With that, I give back to our moderator.
Thank you, Chris. So now finally, the last set of questions should be appearing now. And we will go ahead and start with your questions that we have been receiving in the Q&A box. If you can please, Dr. Hamid, we have a question for you. Does the SCCA wish to become the default arbitration body in the eyes of the Saudi courts? In other words, that the courts nominate the SCCA as the arbitration institution to administrate dispute where the parties have failed to do so. How might the SCCA precede the government to achieve such an outcome? The mic is yours, Dr. Hamid.
Thank you. Just very quickly to have as much as questions that we can. maybe this question has been sent before. Chris gave more details about our project with the appeal court. In brief, we are not gonna administer the ad hoc cases. The parties couldn't, agree. But instead, as per the Saudi arbitration law, if the two parties or the parties, in ad hoc cases, if they cannot agree on an arbitrator, one of the parties, he can apply for the appeal court to appoint an arbitrator. So in these cases, the appeal court is sending to SCCA to appoint an arbitrator or to nominate the arbitrator. So this is the project that we are cooperating with the commercial court of Riyadh. Thank you.
Great, thank you, Dr. Hamid. And now for you, Mr. Gothrop. This is a question that says, on your opinion, how you measure the engagement of Saudi and GCC law firms in the international presence, and what is needed to develop it? I'm sorry, your mic is off.
Thank you. I mean, from a Legal 500 perspective, obviously, the kind of research is at the heart of what we do. So we analyze firms throughout the whole year. I guess the start point for us is that we're looking for firms to put into a submission for our rankings, and indeed for our things like our GC Power List. And then what we have is a research team who will go through that, who will look at the matters that the firm and the individuals have worked on. And it's really an extensive process that probably takes the best part of a year. So we try and really get under the bonnet of what a firm is doing and what is going on. So I hope that sort of goes some way to answering the question.
Great, thank you so much, Mr. Gothrop. And to you, Chris, we have a question. What is the role and task of the CAD, and how does CAD gain its authority by simply agreeing on SCCA arbitration rules?
So the Committee for Administrative Decisions, or in short, CAD, internally we call it CAD, by the way, but CAD is fine as well. The authority comes really straight out of the rules. So rules do provide the SCCA with the authority to determine those three items I mentioned: challenges, number of arbitrators, place of arbitration. This authority has been now condensed into one special committee, and that is actually CAD. And they make decisions. We have had 3 decisions so far, and I am happy to report that we had 3 challenges. 2 have been removed, that is, the arbitrators had to be substituted, and in one case the arbitrator has been reaffirmed. All that has been done within the promised week, which was very refreshing. In 1 or 2 cases, the CAD or CAD even had to go back to the parties and ask for additional information from the arbitrator. So they took the job very serious to ensure that the right decision is made. As you may know, the decision to have an arbitrator is probably the most important determination for parties when it comes to arbitration.
Thank you, Chris. Dr. Hamid, back to you again. So the question is, has there been an increase in the number of foreign awards to be acknowledged and enforced in KSA since the Enforcement Law 2012 enactment?
In brief, yes. And as I mentioned, there is periodic announcement from the Minister of Justice. They are giving, examples about, different arbitral awards has been enforced in the in different enforcement court in Saudi from abroad. And in brief, yes, we are noticing, very active enforcement for international arbitral award.
Thank you, Dr. Hamid. Back to you, Chris. What are the main differences between expedited procedure and classic arbitration?
In short, I would say the timeline. You have seen perhaps that the award has to be rendered within 180 days. So that alone shows you how quick this goes. I'm happy to say that regular arbitrations end up before 11 months expire. In expedited arbitrations, we really hope to do this in under 6 months. And in fact, with this 180-day limit, we are on our way to do so. One arbitrator, big difference. One hearing day, very big difference. So it's not suitable for the large cases, it's suitable for the smaller cases, and it's meant to be that way. That is not to say that even larger cases can profit from this, quite the opposite. If parties believe the expedited procedures would work even for larger cases beyond 4 million Riyal, go for it. It's a matter of party agreement, of course. But those are the big differences, really. One arbitrator, one hearing day, everything. There's a limited round of submissions, and you have really speed in this process that reflects itself also in the costs that are, of course, on the lower end.
Thank you, Chris. Great information. So finally, ladies and gentlemen, I would like to thank our great speakers today and to thank you all for attending and participating in today's webinar. Shortly, you will be, in a day or two, you'll be receiving links to a few of the SCCA publications, including the SCCA arbitration rules and procedure guides, the guide to drafting ADR clauses, and so much more good stuff. So again, thank you, and looking forward to seeing you in future webinars, and have a good day. Thank you all.
Thank you.
Thank you.
Thank you, everybody.
Thank you, David. Bye.